Good evening, everyone, and thank you so much for joining us. We will begin in just a moment, but I'd like to welcome you all to Wine and Wills Estate Planning with attorney Tiffany Gorton. A few housekeeping things. If you want to submit questions during the webinar, please use the chat or the Q&A function at the bottom of your screen. I'll be monitoring those throughout. So with great pleasure, I will now turn this over to Tiffany Gorton, and I'll let her introduce herself. Tiffany?
Thanks, Nora. Hi, everyone. I'm Tiffany Gorton. As Nora indicated, I am a trust and estates attorney, and I do estate planning, trust and estate litigation, as well as probate administration and trust administration. And so tonight we're going to have a little bit of a wine and wills. So I'm hopeful that you have your happy hour drink of choice prepared or poured rather. And I'm going to talk a little bit about some foundational estate planning, as well as a few estate planning updates. So in this world, nothing is certain but death and taxes. So our friend Benjamin Franklin said it best. We're going to talk a little bit about some death-related items and a little bit about taxes, but we could really spend an entire evening, certainly an entire happy hour, talking about tax ramifications, estate taxes, gift taxes, income taxes, you name it. But just by way of just kind of introducing the topic of estate taxes, because oftentimes this is the type of tax that we're planning for in the estate planning world. And so folks hear this as like a death tax or estate tax or inheritance tax. But at the end of the day, what is it? And so this is a one-time transfer tax that's due following a decedent or a deceased person's death if their assets reach certain threshold levels. And so at the federal level, we have an exemption amount of $11,580,000. So I'm hoping to have a taxable problem or a tax problem someday, a taxable estate, but I don't currently. In Washington, though, the amount is significantly lower than the federal amount. The exemption amount is $2,193,000. And so these are kind of thresholds for looking at kind of global assets after someone has died, looking at their real estate, their financial accounts, investment accounts, bank accounts, their life insurance. That's one that sometimes folks forget. And then assessing whether or not they reach that threshold level for filing and reporting, and also for paying any taxes due. So when we talk about estate taxes, that's what we're talking about. And the rates for those are graduated. So in Washington, the rates are between 10 and 20%, depending on the amount of assets that are exposed. And at the federal level, that is between 18 and 40%, depending on the asset levels. And again, at the federal level, $11.5 million, and that's per person. So if you're married, then your spouse gets that same amount, and they have portability at the federal level, so that doubles it essentially. Washington doesn't have portability, so we have some specific tax planning to do if you're in that $2 to $4 million range, to ensure that at a minimum you're kind of capturing both of those estate tax exemption amounts. But as I said, we could talk all evening about estate taxes, and I don't want anyone to drop off and be bored. So let's move into kind of more of the meat of what we're going to talk about, and that is kind of the foundational estate planning tools. So we're going to talk about kind of three pieces in terms of kind of foundational estate planning tools. We're going to talk about durable powers of attorney, we're going to talk about wills, and we're going to talk about revocable living trusts. That's kind of the trifecta of the foundational pieces, if you will. And what I think is really the most important piece is the durable power of attorney. And the reason that I say that is this is a document that takes effect during your lifetime. So wills and certainly revocable trusts are important because where your assets go after you're gone, and the ease with which your heirs are able to transfer those things is very important. But the power of attorney comes into play when you're still living, and so I think that is really the most important piece in terms of having a good foundation. And the word durable kind of in there is kind of an indicator of thinking about estate planning and kind of long-term planning. Some folks, you probably have heard of powers of attorney before, and sometimes you'll hear of them in like a real estate transaction scenario. So for example, if you're abroad and you're going to be closing a real estate sale, you're selling your house or something like that, and you need someone else to sign for you, oftentimes you'll execute a power of attorney just for kind of that limited transaction. Whereas a durable power of attorney, that word durable in there, really gets at durability is ensuring that the document remains valid and effective, even in the event that the person executing it, who executes it, the principal, becomes incapacitated. So in the estate planning context, what you're really planning for is in the event that you're not able to manage finances or your affairs, as it were, yourself, or manage healthcare for yourself, that you kind of have somebody on deck, so to speak. So we're borrowing term from baseball there. You want to have somebody kind of scheduled to be able to step in and manage things in the event that you're not. So in terms of what that person would do, if you think about, all the things you manage for yourself currently, I, pay my mortgage, I make sure my income taxes are filed and the taxes paid, making sure that, my bank account is balances every month, and, making sure that my investments are being properly taken care of by my financial advisor. Those types of things that we do for ourselves, the agent under power of attorney is the person who would step in and do those things for us in the event that, for me, in the event that I was incapacitated, either for a season or for a longer term. And a lot of times we'll think about kind of a grandparent or a parent or an aunt or an uncle or somebody that we know that's been in a circumstance where they had kind of a long-term illness. Most families, mine included on both sides, are affected by, dementia or Alzheimer's. We're living a lot longer, and so we're seeing more of the effects of those types of the effects on the mind of those types of things. And as a result, this is, of the utmost importance to make sure that not only, in the event that I'm, significantly older than I am now, that I have somebody, on deck, but also currently, because we could talk all day about all the different things that could happen to our, human bodies and not think of them, but just making sure that you have someone in place in the event that the unexpected happens. And for the financial piece, you can name a family member, you can name a friend, an individual, or a professional fiduciary. So it might make sense to have the same person serve both in the financial capacity and in the healthcare capacity, or it might make sense to have two different people. It just depends on kind of who your people are, who your family is. For example, you might say, oh, my daughter is incredibly organized. She has this linear thinking. She might be an investment manager. And so maybe she would make sense in terms of serving as an agent for finances, but your son, he's a nurse or has a healthcare background. And so he's more sensitive and kind of more geared toward the healthcare kind of direction, so to speak. So maybe it makes sense to have those two different people. Or oftentimes folks say, I'm going to name my oldest child. It makes sense for me for that person to serve in both roles. It just depends on you, but it's really personal. And you want to make sure that you entrust someone with the finances to who is a good, good steward of their own finances and can manage those things appropriately. And same with healthcare, just making sure that you have someone in place that you've conveyed your intentions to. They know what's important to you. They know your values. And one thing that comes up a lot in terms of the healthcare piece is those end of life decisions. In the event that I'm in a permanent vegetative state, do I want life support? What type of care do I want? And so making sure that you have someone that you can rely on to carry out your wishes in a time that you might not be able to do so is really important. So just thinking about kind of who in your life makes sense, and then having those kind of awkward or tough conversations about what's important so that you're setting that person up for success. Um, I think about anytime I'm talking to clients about this or presenting about it, I think about my stepmom. We lost her at 55. She was very young. And my dad had to make that decision. And it was clear that, she was not going to recover. And the one thing that I was thankful for in that moment is knowing that she and my dad had had those conversations, and my dad knew what she wanted, and that it was, made it somewhat better for him to be able to make that decision. And so really setting up your family and your loved ones for those types of scenarios, just kind of giving them, that little bit of comfort, knowing that they're doing the right thing is, I think, one of, if you need one reason to do it, that's really it. In terms of what is required for a durable power of attorney, I've added a couple slides, one for powers of attorney, and then we'll talk a little bit about the requirements for wills in just a minute. But in the current kind of state of affairs that we're all in with this pandemic and the stay home order, we're having a lot of folks who are kind of DIY, do it yourself. Or even, clients of mine that I've drafted documents for that either, don't, we can't come downtown, or, I'm in my house. As you can see, I'm in my guest room. I'm not in my office. And so some folks are saying, well, I'll sign with a neighbor, and we're social distancing and signing out on the porch with somebody. So making sure that the document that you're signing is valid. It needs to be signed, needs to be dated, and then it either needs to be notarized or attested to by 2 or more competent witnesses. And it is important to note this last bullet point, that it is required to be in the presence of the principal and at the principal's request or direction. This has been an issue that's come up a lot in the legal community. And I gave a presentation a couple weeks ago for the Bar Association on this very topic of practicing in this type of a climate. What are people doing? Because there's been a lot of question, a lot of buzz around, oh, maybe I could just sign my documents on Zoom. And the person, is seeing me sign them, and that person can just serve as my witness, via Zoom or via Skype or via FaceTime, but that's not in the presence. It needs to be in the physical presence. And that doesn't mean you have to be, this close. You could still be social distancing, but just making sure that you are actually seeing the person sign those documents, either if that's on their porch or their deck or in their driveway, however you're doing that, ensuring that you have the requisite witnesses and that you actually have them in your presence. So we talked about durable powers of attorney. And then the second kind of foundational piece that we want to talk about is a will. And for Washingtonians, most folks have heard of this, the last will and testament, thought about it. A lot of you may have executed one. But this document is something that, unlike the power of attorney, this is not effective until your death. So you can change it any time during your life, as long as you have capacity and are living, you can make changes. And this is basically a roadmap. You appoint an executor, and then you provide a roadmap for where you want your assets to go after you're gone. And this can be naming or providing testamentary, which means a trust inside of a will, means a trust that would take effect after you're dead, after the will comes into play. So you can include trust language for minor beneficiaries, for kids or grandkids, making sure that you're not just leaving, a bucket of assets to your, 15-year-old or your 18-year-old, or maybe even your 25-year-old, insert the family member there. And so this is something that is attractive for Washingtonians in particular, because, as we'll talk about in a minute, it's most common, more so than the revocable trust here in Washington, because the probate process is not particularly onerous here. This is also, importantly, wills and durable powers of attorney are where parents can name guardians for any minor children. So in the power of attorney, in the event that I become incapacitated, either for a season or otherwise, I'm authorizing, Bob to serve as guardian and make healthcare decisions for my minor children. Same thing in the will. You make that authorization in the event that I'm deceased. I, appoint this person to serve as a guardian for my minor children. So you can, like I say, appoint guardians here, set up basically just a roadmap for where you want your assets to go after you're gone. And one thing to note here that's important is, and this is something that sometimes folks will say, maybe I want to use a revocable trust instead of a will. A will is filed with the court after a person's deceased. You don't have to file it before you die. Historically, there's been some counties, particularly rural counties, that have like will repositories, but you don't need to file your will with the court for storage purposes or to make it valid. But after you're deceased, that's when the executor will file your will with the court so that they can begin the probate process. And one thing that folks will say in kind of thinking about wills versus revocable trusts is related to kind of that public piece. Sometimes folks will say, ooh, I don't like the idea that that's filed with the court. I don't know how many people are trolling the King County Superior Court website, or any county for that matter, to look up people's wills, but they are there. And so it does, for all purposes, mean that it's essentially becoming a public document. But it is where you appoint your executor. And like I say, in terms of kind of the probate process, we're going to talk about that in a minute, but under the terms of a will, it gets filed with the court after death, and then the probate process begins. And that's where the executor comes in, kind of gathers all of the assets of the deceased person, makes sure their creditors are paid, any debts that they owed are paid, and then make sure their final tax return, their income tax return is filed, files an estate tax return if that's required, based on what we talked about before in terms of those threshold filing levels. But what is required for a valid will, again, because this is something that's coming up in practice right now because of the social distancing and, the stay-at-home order, is we have to make sure it has to be written. And so this is seems like a no-brainer, but there's a lot of case law dating back years and years of like, what's a writing? And so there was, one case where someone had carved, their notes on like a seashell, or, scratched it into the sand at the beach. Well, until high tide, that could be valid. But these days we're writing our wills on paper. So it needs to be a writing, and it needs to be signed by the testator. So if I'm making my will for Tiffany Gorton, I'm the testator, so I have to sign. And it also needs to be signed by 2 or more competent witnesses in the presence of the testator. Remember, that's key, making sure that you have 2 witnesses, because a will witnessed by one person is an invalid will. So make sure that those witness requirements and signature requirements are met if you are signing something on your own. Here's a little cartoon. This is the cat visiting the attorney's office. He'd like a will prepared, and he would like 9 of them. So I think that given 9 lives, he will need 9 wills. So the other kind of foundational tool that we're going to talk about is the revocable living trust. And as I mentioned, there are some differences between this and a will, and there are some kind of cost benefit things to weigh when deciding if a will is right for you or if a revocable living trust makes more sense. And there's the funny thing is, it seems like revocable trusts always are, my neighbor has one, or so-and-so says I need this. Susie Orman is a huge proponent of revocable living trusts. I do not know if it's because she's from California, where everybody uses these as their primary estate planning tool, or I don't know where that comes from. But this is one thing where a lot of folks will say, oh, I really need a revocable trust. And then I say, why? Because in Washington, as I mentioned, kind of the probate process is not particularly onerous. And usually the revocable living trust is used as a means to avoid probate. So it provides a roadmap for assets post-death in the same or similar way that a will does, but it becomes active during life. So the will you execute, and then it sits, in your safe deposit box, in my will vault, in your, wherever you keep your safe papers or your important papers, until death, and then it's filed with the court. Whereas a trust is not filed with the court, but it's active kind of during your life. So if I were using a revocable trust as my primary estate planning tool, I would, instead of owning my house as Tiffany Gorton, which is how I currently own it, I would own it as Tiffany Gorton, trustee of the Tiffany Gorton Revocable Trust. So you change title to certain assets during your lifetime, and that means that ensures that your trust is properly funded, and therefore, if it's properly funded, it can avoid the probate process. So basically, it's something that kind of comes into play during life. You don't pay your taxes any differently. You still have to pay income taxes in the same way that you normally do. You still pay your property taxes. You still pay your mortgage. And one key important misconception about revocable trusts is it's not a tax, an estate tax savings tool. So there are a lot of trusts that are designed to shield assets from estate taxes, but the revocable trust is not one of them. So assets held in a revocable trust or outside of a revocable trust at death are going to be counted for the global estate and whether or not you have to file an estate tax return or pay any estate taxes either in Washington or at the federal level. So as I said, this is essentially, it's a box that holds title to your assets while you're living. And then at death, the assets are going to be distributed pursuant to the terms of the trust, similar to how a will provides a roadmap. And as I mentioned, this is a tool that's used oftentimes for probate avoidance, which we'll talk about in just a minute. We talked a little bit about what probate is, and we'll talk a little bit more about that. But in Washington, because as we're going to talk more about, probate is not particularly onerous like it is in some states like California. And so there are really only a few reasons where I will typically say, a revocable trust might be more appropriate than a will for certain Washingtonians. So sometimes folks will say, well, I'm just really comfortable with a revocable trust. My parents had one, or my sister had one, and I served as her trustee. And so if you're familiar with it and you just say, I'm comfortable and that's what I want to use, then that's fine. That's entirely, up to each individual what makes sense for you. The times where I will say, hey, maybe we should at least have a conversation about using a revocable trust is if you have out-of-state real estate. That's the biggest one. So for example, you live in Washington, but you have a house in Idaho, or you have a house in Oregon, or really any other state other than Washington, you have real estate. And to avoid having to do what's called an ancillary probate, meaning you have to go through administration in Idaho and in Oregon and in every other state that you have real estate plus Washington, then I'll say, you know what, if you have something outside of Washington real estate, then a revocable trust might make sense, because what you can do is title all of that real estate, all those different real estate parcels, houses, whatever, in the name of the trust. And then you don't have to go to probate in all those states. You can just, the assets will flow appropriately through the trust without going through the probate process. So that's one time where I think that makes sense. Another time is, and again, I mentioned at the beginning that my practice focuses on not only estate planning, but also trust and estate litigation. And we see a lot of folks who want to come along and contest wills or, otherwise stir things up, so to speak. They want to cause trouble for beneficiaries, cause trouble for a fiduciary, for an executor, or, just say, oh, well, mom meant to include this for me, but she forgot. And, all these other types of nefarious behavior. So if you have someone that you say, you know what, we have this black sheep, one of my children, one of my siblings, somebody in the family who might come along and want to stir things up, so to speak, after I'm gone, then sometimes a revocable trust makes sense because it's a little bit more private. So as I mentioned, the wills, after you're deceased, are filed with the court, and then they essentially become kind of a public record. Again, there's not like social security numbers or account numbers in your will. So it's not that everyone has access to all your private information, but they can see who your beneficiaries are. And so by not having something that gets filed with the court, like a revocable trust, then a person who wants to contest it or otherwise cause trouble surrounding it has additional hoops to jump through, because they don't just have access to the document. For trusts, the only folks that are entitled to request a copy are the trustee and the beneficiaries. So if you leave someone out, if you disinherit someone, so to speak, sometimes a trust can be more useful because that person's not entitled to see it, and there would be more hoops to jump through if they did want to cause some trouble. And at the end of the day, regardless of all the good planning that we go through, if somebody wants to cause trouble, they're going to come along and do everything they can to do that. But this just puts a little bit more of a kind of stopgap, couple more hoops to jump through, so to speak, rather than just having access to it on the county's website, so to speak. So we talked a little bit about what probate is. In avoiding probate. And like I said, it's a court supervised process of basically gathering the decedent's assets, accounting for everything, making sure that my American Express bills is paid, making sure that my house is liquidated, my house is sold, if I own real estate, or making sure my house is distributed appropriately, if it's something that is going to be distributed to one of the beneficiaries. Ensuring that, all my accounts are accounted for, making sure that, they go to open the safe deposit box, make sure that, they clear everything out of there, and file my final tax returns. If I was delinquent and didn't file tax returns, catch up the tax returns. That's sometimes something we run into with probate administration. If someone hasn't filed for a couple years and needs to. But just making sure that basically all my final affairs are wrapped up. That's what probate is. And in order to do that, the court has to basically provide what's called letters of administration or letters testamentary. It's a piece of paper signed by the court that says, this person is Tiffany Gorton's executor, or this person is Tiffany Gorton's personal representative. They have the authority to manage her assets now that she's deceased. And so then that person is charged with gathering everything and distributing it according to the terms of the will. And so that is, or if you do nothing, no estate planning, no will, no trust, just nothing, then you're what's known as intestate. Then your estate is going to pass according to how the good folks in Washington have designed it. The rules of intestacy is what that's referred to. And so for probate, assets go through probate if you are using a will as your tool for estate planning, or if you just do no estate planning with some exceptions. So it's easier to say what is a non-probate asset than what's a probate asset. So in terms of what types of assets do not require probate, assets that are titled as joint tenancy with rights of survivorship, JWTROS. That is on a bank account, for example, like my savings account or my checking account. Oftentimes, particularly spouses will have these types of joint accounts, meaning that they're both owners, and the survivorship provision means that when one owner dies, the other one who survives automatically owns that account. Now, this can be a trouble spot because sometimes folks will inadvertently add like a child or another family member to their account, thinking, oh, this is really a good idea because if I add them to my account, then they can help me with my finances if I need someone to write checks for me or otherwise, assist managing the account. Now, if you have a validly executed durable power of attorney, you're not going to need to add anyone to any of your accounts because you have a document that's a legal document that provides your agent with the authority to do those things. So you don't need to add anyone to your accounts in order to do that. And sometimes you can inadvertently make someone else an owner. And so, for example, I add my, oldest daughter to my bank account so she can help me, but then I have 3 kids total. And when I die, my oldest daughter owns that account. And really what I intended was for all my assets to be split 3 ways among my children. So just make sure that any accounts that you do have that are titled as joint tenants are really intended to be titled that way, because that person, in my example, my oldest daughter, is not required to share that account with her siblings after I'm gone if she's a joint owner. Property that's subject to a community property agreement, that's something that we have here in Washington, where that's between spouses, and basically provisions for assets that are going to pass or become community assets and pass to the surviving spouse. Those assets are not going to be subject to the probate process, because they're governed by a contract, which is the community property agreement. Property held in trust is not going to be subject to probate. So that's, again, the revocable living trust, for example. That's where that comes into play as a probate avoidance tool. Any property, like there are some special trust tools that are different than the revocable trust. For example, there's a special trust that uses that holds life insurance policies, and so any assets, any life insurance policies that are held in that trust are not going to be subject to probate. So any type of trust that holds assets, the assets that are held in that trust, that are titled in that trust, are not going to have to go through the probate process. Life insurance policies, aside from using a life insurance trust, just a life insurance policy on its own is also not necessarily going to have to go through the probate process. So any financial accounts, insurance policies, investment accounts, retirement accounts, any of those types of things that have a beneficiary designation associated with it are going to be non-probate assets. So it's really important to make sure that those types of assets that you've executed, that you've signed your beneficiary designations, and making sure that any accounts that do have beneficiaries on them represent your current intentions and mirror kind of what you've developed in your estate plan. So for example, you want to make sure that if you have an investment account that goes to my oldest daughter, but you really want all of your assets under your will to go to your 3 children equally, make sure that your beneficiary designation comports with what your estate plan says. Or if you say, I'm reserving this specific account for my oldest child and everything else is going to pass under my will 3 ways, that's fine. Just make sure that they represent your current intention. Okay, so in terms of kind of a little bit of an update, one of the acts, and this is not the CARES Act that was passed as a result of COVID-19. This is the SECURE Act. This was passed at the end of 2019, the Setting Every Community Up for Retirement Enhancement Act. And this became effective January 1 of 2020. And you may have heard about this because it primarily changes the effects on retirement accounts, individual retirement accounts. You probably heard historically that there was a stretch provision. So if I left my retirement account to my spouse or to my children, equally among my 3 children, those children could take the distributions from my IRA over the course of their lifetime. They could stretch out those distributions. Well, this SECURE Act has changed that. And so historically, those types of retirement accounts were used as kind of a wealth transfer vehicle. They were used to basically to benefit beneficiaries. Sometimes folks used them to fund the retirement, but oftentimes they were treated more like an asset to be left to children or grandchildren or charities, etc. And now it's a little bit more complicated to do that. And there's the reason being that now, instead of just having everyone be able to receive that stretch provision, that stretch of payments, there are only 4 categories of beneficiaries. A spouse, so a spouse still during their lifetime, they can take distributions. So if I die and I leave my IRA to my husband, he can take distributions over the course of his lifetime. But everyone else, unless they fall into these 4 categories, are going to be required to take distributions within 10 years. So your spouse is covered. They can still stretch out those distributions. If you have a minor child, then they have the benefit of waiting until they're 18 for that 10-year period to begin. So if you have a 15-year-old, for example, and they inherit your IRA, their clock doesn't start ticking until they turn 18. but within 10 years of turning 18, so age 28, they have to receive all distributions of that account. We're going to come back to this one in a minute. The other two categories are if there's an individual that's less than 10 years younger than me and I leave this IRA, this retirement account to them, they can stretch it out of their lifetime. And then finally, disabled or chronically ill beneficiaries are able to stretch out those distributions over their lifetimes. So unless someone falls into those four categories, they're going to be required to more quickly take those distributions. And that can have some income tax ramifications depending on the size of the account, the size of the distributions, and what income tax bracket the beneficiary falls into. So the one important kind of point here that I want to make from a planning perspective is sometimes folks will say, you know what, I have these minor children, they're 5 and 7. I can't, I don't want to give them my retirement account. I certainly don't want them to take all distributions between age 18 and 28. I want assets to be preserved until they're 30, 35, 40. We all have either minors or other people in our life that might just need some additional management of those funds. And so there is some trust planning that you can do in order to do this. There's two types of trust that we refer to with respect to retirement assets. And there's conduit trusts. And under these types of trust, the trustee has to immediately distribute all of the retirement plan distributions. So it's going to fall into that 10-year rule. The other is accumulation trust. And those types of trusts can accumulate retirement plan distributions inside of the trust. And so, for example, if you do have those minor beneficiaries where you say, it's more important to me to, not be so concerned with the income tax component, but to protect those assets for a longer period than that 10-year period, then you would want to use accumulation trust type language. So this is more than kind of basic estate planning, more than kind of the foundational pieces, but it's worth noting because a lot of people use retirement accounts, a lot of people have IRAs, and just to make sure that what's going to happen after you're gone with that IRA comports with your intentions, be that either, using the 10-year time frame that's provided under the Secure Act, or thinking through the use of a trust for certain types of beneficiaries. The accumulation trust can also come into play if there is a beneficiary that has that's disabled or would be otherwise qualify for certain government or charitable programs. And in those types of circumstances, using a special needs trust with this type of accumulation trust language in order to provide that the retirement benefit, the IRA, is able to appropriately be distributed for that person's benefit versus naming that person as a beneficiary on the IRA and then suddenly kicking them out of those types of benefits that they might otherwise qualify. So just kind of food for thought, thinking about retirement accounts and kind of some changes to the law there and making sure that your intended beneficiaries can receive those assets as you intend. And, there's just a little bit of additional kind of heavy lifting to do as opposed to pre-Secure Act when there was more flexibility and more stretch provision available for more folks. So with that, this is, I mentioned that folks are signing their estate planning documents outside their houses. So this is my husband and I serving as witnesses for one client on their deck, 6 feet apart. But he dressed up, he picked cowboy and I picked bandit that day. So that's how we got their estate planning documents signed for them. So with that, I'd like to open it up for questions. So Nora, if you have any questions from the audience, please share them.
Yeah, so if anyone has questions, go ahead and put those in the chat and the Q&A. I did have one question from someone asking if you'd be able to share these slides.
Oh, sure. I think that's just fine. I'm happy to do that. Is that something that is easier for you to do or for them to email me directly?
Yeah, why don't you send me a PDF version of it and I'll make sure to get it sent out to everyone who attended today.
Perfect. I'll do that.
Okay. I had a question while we're waiting on other folks to write things up. speaking of changes that happened this year, wasn't there something about um, electronic notaries being available in Washington state?
That's a great question. And that has been much like the discussion surrounding presence. How does that come into play? And so that was interesting. I actually assisted with the Bar Association in commenting on that legislation a year ago when it was getting ready to be passed. So that's a little bit more of how the sausage is made, but that was pre-COVID when we didn't know that we'd want to do so many things remotely. But that was primarily directed by the real estate folks. As you can imagine, they're notarizing a lot of documents. But one thing that does fall into that camp is the durable power of attorney. So that's something that can be remotely notarized as of, I think that the statute goes into effect June 1. The Remote Notary Act is already valid and already in effect. But there's a secondary piece of legislation that does kind of talk about which types of documents are able to be remotely notarized. So I think it's June 1. But the one issue we've been running into is getting the licensure for being a remote notary. Like I'm a notary. So if you need to execute something and need me to put my stamp on it, I can do that. But that doesn't mean that I can get on Zoom and watch you sign something and then just stamp it. So what remote notarization is basically the notary is looking in real time at that document, and the person is signing that document like via DocuSign, how you would sign like a real estate transaction. When you buy a house, you have to do all those signatures throughout. And so the remote notary can notarize a DocuSign type signature via a remote connection. And there's some secure software that comes into play and ensures that everyone is being able to, that the notary and that the signor can view the document at the same time as it's being remotely signed via DocuSign. And there are, notarize.com is a good resource for that, for the remote notarization, because that is, some other states like Texas, for example, has had remote notarization for a long time. And so notarize.com works with all 50 states, whereas the licensure here, there's a process to go through to get that designation. And so it does take a couple of steps.
Okay, so we do have a few questions. I have very little money. How do I plan, budget safely in Plan? Are there good online tools? Also, how is probate here not as onerous as it is in other states like California?
Okay, so that's a great question. So I'll tackle the probate one first. So in California, for example, it's an expensive process, and I think that the administration attorneys are paid based on a percentage of the asset value, and so it's more expensive. It's also a clogged and timely clogged system, making it a really long-term time that you're going through that process. So the court being clogged requires an awful lot of time, the expense of it, and so as a result, people want to avoid it, which is why that revocable trust is used there as the primary tool. In terms of Washington, it's a $240 filing fee. You pay that fee, you file the will, or you file declaration saying there's no will, and then you're off to the races, meaning then you get the court's authority, that letters of administration to serve as the executor, and then you're going forward and can do all that legwork. So there's not really a long-term commitment to be involved with the court, so to speak. And there's not like a percentage of the asset value that's going toward any type of fees. So it's a lot cheaper and quicker.
Okay. So Washington, easier, quicker, cheaper. California, harder, more expensive.
Right.
Okay, thank you. Two questions from the same person. I have a 401k and several IRAs. I'd like to leave to a 501c3. How does taxation work on this? What about leaving a house to a charity? The house is paid for.
That's great. I'm so happy you asked that, because one of the things that I wanted to mention was, in addition to the historical value of being able to maximize income tax benefits on retirement accounts by leaving them to charity, if you're charitably inclined, particularly under the Secure Act, leaving those assets to charities like the People's Memorial Association, for example, shameless plug. um, the they don't get the income tax hit. And so, and Nora, you might be able to speak a little bit to kind of what that looks like in terms of receipt for the organization. But for individuals, like if I am the recipient of your retirement account, then when I'm taking distributions, I'm going to have to pay the income tax on those distributions at my income tax level. Whereas for a charity, they're going to pass tax free, and you're not in a position of worrying about that 10-year time frame, because the charity can just take it and there's not an income tax impact there.
Yeah, and it also will depend on the size of the charity, what their capacity is for receiving large gifts like that. I know a lot of smaller charities, if they do get a significant contribution from a retirement account, or I haven't heard of anyone donating a full house as of yet, but like cars and stuff like that, I've heard stock accounts, they usually sell them off as they receive them rather than keep and maintain like a brokerage account in order to keep those stocks.
Mm-hmm.
So just things to think about like that.
One other point there with respect to transferring a house or leaving a house to charity, as it were, is thinking about when you design your will, if you say, you know what, I really want the proceeds from this house to go to a charity, or the house in general, you can include that as like a specific gift where you say, you know, I give this house to PMA, or I give the proceeds from my house to PMA. The other thing you can do is include like a percentage or otherwise of just the residue of your estate, which means that your house, any other assets that pass through there, not necessarily the retirement accounts, because you can include beneficiary designations there. But that way it's, you know, what if you sell the house and move, and then the house doesn't exist, but you don't update your will, but you have the cash, you know, available. So just making sure that you don't kind of short circuit what the end game is, or the end goal is.
Okay. For the estate tax exemption amount, is this after you subtract the non-probate assets?
So no, the estate tax is going to be applicable to all the assets, non-probate assets and probate. And the one that people oftentimes forget about is life insurance policies, because it's not something that I'm going to use because it's on my life, and then I'm going to die and someone else is going to get that, you know, $100,000 or whatever. So all probate assets, all non-probate assets, real estate, bank accounts, all those assets are going to be looked at to get that big number. And then the exemption amount is going to apply. And that's how you determine whether or not there's going to be any tax owed.
Okay. And then can you define what revocable means? What makes something revocable?
Yes. So revocable with an R at the beginning, not an IR, means basically that you can revoke that trust during your lifetime. You can completely revoke it and say, you know, I'm destroying this trust and I'm going to, you know, make a new estate plan. You can change that trust during your lifetime. It's not something that is irrevocable with an IR, meaning, you know, I made this lifetime gift to it and now I can't take it back. You can always revoke it. You can take it back. You can cancel it. You can change it during your lifetime.
Okay. And then for folks that don't have a whole lot of assets but want to put together a will, what is an economic way that they might be able to put that together?
That's a great question. I think that was part of a question from before that I missed. So basically, at the end of the day, even if you have a Buick and a base fiddle, you still want to make sure that your things go, you know, where you intend. You want your appropriate executor to be appointed, and you can use certain online resources if you wish. A lot of attorneys do pro bono or low bono, meaning free or reduced rates depending on the circumstances. And there's also the King County Bar Association, the Washington State Bar Association has resources for certain types of estate planning clinics, like first responders. There's some Native American resources, and there are just other resources through those organizations for this type of planning. And so you can do it yourself, which my late law partner, Tim Burkhart, used to say, I could wire my own house, but I want to live there. And sometimes we've seen kind of odd things that can come up with online programs. Like, for example, Washington is at the end of the list of states, right? Because it's a W. So I click on the drop down menu and I'm going to go to Washington, but then it pops back up to the front and takes on Alabama. So suddenly I've created a will inadvertently under Alabama rules. So just things like that to watch out for. But there are a lot of other professional resources, like I said, aside from doing it yourself.
Can you clarify the durable power of attorney and how it's different from the executor? As I only have one daughter who would get everything and she's going to handle it all. Are there professional powers of attorney or executors, or are there professional powers of attorney or professional executors, someone who might be less emotionally involved?
Yes, absolutely. So the agent under power of attorney is the person who manages finances and or healthcare while you're still living. And the durable power of attorney effectiveness ends at your death. So when you breathe your last breath, then the durable power of attorney is no longer the governing document. Then your will comes into play. And so people oftentimes name the same person as agent for finances as they would name for executor under the will, because they have very similar involvement with finances. Just one is during a lifetime and one is after someone's deceased. So in those circumstances in particular, and I'm an only child too, so if there's just one of me, one and only, then you're managing assets kind of for yourself at the end of the day as executor. But one point that's important about is kind of somebody who's not emotionally involved, or maybe your only child has 6 kids, 5 dogs, and 3 cats, and is very busy and doesn't want to go through serving as an executor because it's a job. Serving as an agent under power of attorney or as executor under a will or as a trustee is a job. It's a lot of work. And so there are professional fiduciaries, and not necessarily big bank trust departments, but there are local professional fiduciaries that serve in those capacities. They charge a fee, of course, but they're able to serve both for finances. It's a little bit harder to find someone to serve for healthcare because that's somebody who would be in a position of making end of life decisions for you. But for that, I would recommend, if it's appropriate, having a conversation with either the child or family member or a friend, and having an individual person appointed for the healthcare piece.
Yeah. And then because you mentioned it, and this is People's Memorial, a durable power of attorney does not have the ability to make the funeral arrangements as well. So you need to get what's called a designated agent if you don't want the next of kin line to be the ones that are handling the funeral arrangements. A lot of people come to us and assume because they're power of attorney that they can then handle the funeral arrangements. But as Tiffany said, power of attorney ends at death. So that doesn't count anymore at that point. So you will either need to have your wishes in writing for what your funeral arrangements are going to be, have a designated agent, or trust that the next of kin is who will appropriately be able to authorize whatever arrangements you want to have.
Thanks for pointing that out. And that's one thing that, particularly if you work with an estate planning attorney, they will prepare a disposition of remains statement, citing kind of the Washington statute that I want to be cremated or buried or however they see fit. I'm holding out for sky burial.
If one person in a couple dies, do the assets have to go through probate or estate taxes?
So it depends. It depends on how those assets are directed. It depends on if those people are married as a married couple. If everything is going to the surviving spouse, then there would be no estate tax due, because regardless of if every asset goes outright to the spouse or in trust for the spouse, there's an unlimited marital deduction for estate taxes. And so typically in a marriage or marriage-like situation where there's, in Washington, we have registered domestic partners. So if you are married or a registered domestic partner, then you're going to be able to get the unlimited deduction at the state level for tax purposes. In terms of probate, it depends on how the assets are titled. So for for real estate, sometimes you will have to either do a lack of probate affidavit or open a probate so that you can get the title, get that surviving spouse or deceased spouse's name off the title. typically for accounts, depending on how they're owned. If it's owned just by that deceased spouse, then you might be in a position of having to open a probate to get those assets transferred, to get title transferred.
Okay. So it's a good idea to go over your accounts and your assets and figure out where there's right of survivorship, who are the people on it, and that kind of thing in general.
Exactly.
Okay. How complicated, or how to make less complicated, if one wants to give their home to a nonprofit in India?
Interesting. Well, I love to make things less complicated. That's what I think the name of the game is. I have had, this can be very different country to country, whether you hold an asset in the country, in a different country, or you want to transfer assets to certain other countries. And I've had, I have a client that we drafted the estate planning documents and then worked on the probate administration as well after she died. And she left the bulk of her assets, which included some real estate. She left basically a percentage, like 75% or something like that, to an organization that was in Africa, that was a children's organization. And so it didn't, in that particular set of circumstances, the charitable deduction wasn't there because it wasn't a 501c3. That particular organization wasn't. And so there wasn't a deduction for her estate, but they're a beneficiary, they're named in her will. And so there's really no question as to whether or not they're going to get those assets, because you can leave your assets to any individual or organization that you see fit. So I would just make sure that you include the correct name of the organization, maybe a contact person for the organization, address, any type of information like that, rather than just leaving your executor to kind of guess and try and find that organization.
No. And I would think, and correct me if I'm wrong, is if a home is something you can't physically transfer to another country, so would there be a reason to maybe put language of the proceeds of the sale of my home will go to this place, or some kind of language like that?
The executor will have the authority to sell the house regardless of whether you designate the proceeds or not. But in all likelihood, an organization, a charitable organization here or abroad, is probably not going to utilize a house in a way that, they're not going to use it as a vacation home. They probably aren't going to use it as a rental property in the way that a human would. And so at the end of the day, the organization will likely ask that it be liquidated and then that the proceeds be distributed. So you don't necessarily have to designate that.
Okay. I think that's all of our questions. Thank you so much, Tiffany, for doing this evening.
Absolutely. This was really fun. Thanks everyone for joining, and stay healthy and keep washing those hands.
Please. Yes. I'm just going to give a little information about what People's Memorial does, but thank you everyone else for attending today. So People's Memorial Association is a membership organization, and actually over 215 people have joined in our 80-year history, and we currently have about 72,000 living members. We are the oldest and largest memorial society in the US, and we're the only nonprofit in Washington providing funeral education and advocacy. And members are also members of the Funeral Consumers Alliance, which is a national organization with about 69 affiliated sister organizations across the US. Memberships are currently $50 per person, and with those memberships, you have access to discounted rates at over 25 contracted funeral homes, 4 contracted cemeteries, and you are part owner of the Co-op Funeral Home in Seattle. Membership entitles you to information and education around death care and funeral planning, discounted pricing at select funeral homes, including a pet funeral home in Seattle, select cemeteries, and a monument company. We provide all sorts of planning documents around end of life, and we hope that by learning what the process is and having your plans in writing, that it'll ensure that you are treated with dignity and respect, with no sales pressure at a funeral home, and you get to participate in the cooperative process. We have these educational programs. We've got a full program called Ducks in a Row, which includes estate planning, advanced directives, and funeral planning. But right now we're really focused on what we call the Ducket List programs, which are single subject programs around separate end-of-life issues, just like what Tiffany did for us today. And so we can help provide the planning documents to get your paperwork in order. We screen the funeral homes that we partner with for you and negotiate the price discounts so that you know that there's not going to be any surprises and you won't be upsold and no sales pressure at any of our partnering funeral homes. And we do support our member families in need with our Cremation Assistance Fund. If folks don't even have the financial resources to do a simple cremation, we do have a fund that can help with that. We advocate on your behalf, and we offer greener burial and cremation options, and we've lobbied to make greener disposition options legal in our state. And we also ensure that there is funeral pricing transparency through our funeral home price survey, which we're currently working on our 2020 version, where we compare the pricing of all the funeral homes across the state of Washington so you know what to expect in your area. Because we want to make sure that all Washington families are able to make end-of-life choices that reflect their own values and are within their own family budget. We want you to think about what you want, talk about your end-of-life wishes with your loved ones, and put it in writing today. So thank you for attending today. If you have any further questions or you think of something later, feel free to contact us at info@peoplesmemorial.org, or our phone number is 206-325-0489. Thank you so much for coming today, and we'll hopefully see you again at another one of our presentations soon. Thanks.